All right, good evening, folks. Welcome to Monday Night Law on Kirk's Law Corner. Yep, got the notification. There it is. Hope everybody had a wonderful weekend. I was pretty good. Had a nice little barbecue there with the family. Quite the group of us together there for Father's Day. Although I'm currently not being allowed to be a father, so uh, that may be changing here soon, given the recent events. They wanted to open up that can of worms, and now I'm a little bit more prepared. They wanted a little bit more knowledgeable, a little bit further down the road in knowledge. So I think might be a little more successful when I go back in. But I can tell you, things are gonna be things are gonna be changing for me. That's for sure. And some things might be seriously changing in Idaho because of it. So, um, hi Amber, hi Cece, hi Bobby. Been watching them educational series over there, Bobby. So I want to put that plug out again for donations to help with the new space, the new office. If you could help support that, getting us in there, I'd greatly appreciate it. If you could send those over to the current office right now, 6477 West Fairview Avenue, Suite C, Boise, Idaho. Which I'm gonna put that up in there. Jameson's already got that over there. Oh, um, yeah, this one. Should yeah, move that over here. And of course, over on Patreon is another good way to help support. Patreon /Kirk's Law Corner. Wednesday night workshop over there. Been having some pretty good meetings over there. So if you're not aware of Wednesday night workshop and want to get in on that, again, the other part of all that is that once I get into this new venue, which is rather large for where considering the office space that I have now, I can fit roughly around 40 people in the main area, plus all the other office space area. So that's quite the upgrade. Again, it's a lot more expensive, but um, with what's going on there, and I'll be able to host law seminars right out of my own venue, and I'll be able to do some of those videos, record some of those seminars or whatever, and put those on Patreon. That's where the good stuff's going to be. Because, hey Bob, how you doing? Got to meet Bob this weekend at a Ammon Bundy announcement for running for governor and his plan. Got to meet one of my followers out there. It was nice to meet you there, Bob. But yeah, it's there's a lot of things that we can't talk about here on Facebook and YouTube. And yes, I'm still looking into trying to use Restream and broadcast on a couple different channels out there, Rumble and possibly BitChute. So We can get into some other stuff that we just can't talk about on here. I'll get banned, which I've gotten a couple of warnings, which I haven't gotten any warnings for a while. But that thing that we can't talk about, when I do talk about it, they give me a warning about it. But the funny thing is there's some, I don't know, truth coming out now with like, you know, people's emails, records, the truth, who's behind it, what's been going on. There is there is a lot of other things that are going on behind the scenes as well. I'm just it's man, the best is yet to come, and it is coming. I have it on pretty good authority that lots of people are getting arrested. Let's just put it that way. And as for Field, of course, being asked that again, he's, as far as I know, he's at home enjoying life and following the order as it is. So, you know, I feel bad for Field because of his wife dying, and they played games with him and not letting him go back home to his wife after she passes away. Oh yeah, and exposes the fact that uh, she lied, and there's some hokey stuff that went down, and relief was not granted when it was due. But make no mistake, I'm still watching, waiting to see what they're gonna do. Right? Yeah, there's all that stuff coming out too, which we can't talk about that stuff either, right? We can't talk about too much of the truth of what's really going on here, but over on Patreon I can. And the people that are over there on Patreon get to have access to Wednesday night workshop, and I share quite a bit of things over there about what's really going on and what we're working on. Of course, we can't share that here because we don't want to let our enemies know what's coming for them. So, just saying, not everything is what it appears to be, and especially in this day and age with fake news and uh, who's in control of the news, you're not going to get the truth, right? Yeah, yeah, I know, I know. I can't repeat what I'm reading out here, and even then, it still might get a little warning on your comments. But well, thank you, Diane. Hey, Diesel D's, good to see you, brother. This is the thing is I keep repeating this, and the Bible talks about my people shall perish for lack of knowledge. This isn't just dealing with law and what I'm teaching here and how I'm trying to educate the masses of what the law says as it is written. I'm talking about just in general. Do you have to hit your thumb with a hammer to know that it's going to hurt? If you don't have, some modicum of common sense and have the smarts, to question everything. Do your own research. You're going to perish because you are going to hit your thumb with a hammer. And after you hit your thumb with the hammer, you're going to say, ouch, it's going to hurt. So there's the, you know, there's your cue. Cue you in. Wake up. You don't actually have to hit your thumb with a hammer to know that it's going to hurt. So people not doing their own research, not educating themselves, is going to get themselves killed or extremely sick and then die. Maybe I just grew up in a different time, which I did. Things are not even close to what it was like when I was growing up in the 70s and the 80s. And there's plenty of people out here that are a little bit older than I am that can affirm that. I've had several conversations with my grandmother and even my mother. We've had some roundtable discussions about how things used to be and how things have changed. And, you know, I pretty much am in, Gen X there, the last of the somewhat free society of, what we did, how we played in the streets. And, you know, can't do that. Can't do that today. Kids are getting kidnapped right off of the streets. We were, you know, we didn't have cell phones, we didn't have computers, we didn't have all the fancy gadgets and gadgets that we have today. So, when you got home from school, it was do your homework and then go outside and play, come home for dinner, go outside and play until it got dark. That's just the way it was. Um, what else was there to do? Go ride your bikes. Skateboards came in my era. It's just not the same as it used to be. Our economy is way worse than it used to be. It keeps raising the minimum wage. Oh my gosh, there's so much crazy stuff going on right now. I keep seeing signs around now here just in my local area, hiring $11, $12 an hour at McDonald's. What? For real? And then they're still hiring. They still can't get people to come in there and work. Do people realize what this is going to do to our economy? It's going to tank it. It's going to trash it. We're going to get to where a loaf of bread is freaking $10. Gallon of milk's going to be $15. Right? Kick the can, capture the flag, neighborhood games. Oh man, the good old days. Frisbee, football, baseball, lawn darts. Yeah. Horseshoes. Anybody still play horseshoes out there? How about dominoes or Yahtzee? You know, those were inside board games. Sorry, Parcheesi. I don't know. There's so many different card games. Worse, lots of card games. How about throwing rocks at each other? I mean, crap, we did that. Yeah, cribbage, pinochle, spades, hearts. It's pretty crazy. Right here in the house that I'm in right now. When I was a kid, right here, played Yahtzee and card games with my grandfather. Good times. Um, just don't do that stuff today. You know, I don't know we'll ever get back to those kinds of things. I think with the electronics the way they are these days, that these kids are just, constantly glued to their phone, you know, glued to some sort of device, tablet, laptop. It's uh it's definitely a different society today than it was when I was a kid. And while I think some technology was good, I think some of it's bad for our society. But what do we do? What do we do about it? I mean, not much that we can really do, right? Build forts. Yeah, there was a good one. Looking for crawfish. Yep. Oh, there's some good old days. Went to ballet and music class and then came home and made dinner, right? Yeah, sunlight magnified on ants. There was a good one. Cooking the ants. Oh yeah, volleyball. That's one of my all-time favorites, to be honest. I really like playing volleyball. I tried that ice skating thing and I just could not. I couldn't do it. I could not do the ice skating. Now, roller skates? Yeah. Ice skating? No. Same thing with like the rollerblades today. I can't. I've tried rollerblades a couple times. Couldn't do it. Remember we used to play Cowboys and Indians? Used to play Army with plastic men, Cowboys and Indians with men, little plastic men. Although we played Cowboys and Indians too with those old pop guns, marbles and jacks. There's some good ones. Yep, bringing back the old days. And where are we at today as a society? Again, back to being glued to some screen. And I mean, again, don't get me wrong. There's some positive stuff to uh, right now. Electronics, right? This wouldn't be able to be happen right now if we didn't have the technology that we have now. So spitballs. Save your straw from lunch for spitballs. Yeah, hide and seek, doing stuff, getting yelled at, of course. Always getting into trouble, right? Used to have nickels. I don't know. You could do that one. Hammer down nickels to the size of a quarter and play asteroids at the arcade for hours. That's pretty slick. Oh, missed one. Yeah, yeah, surely. When all this is over, we can live again. That's true, but I think technology has stolen uh, the good things in life. Where kids would go outside and in the neighborhood and ride bikes and play with each other and you know get to know each other and I don't know, chase the schoolyard bully. Red Rover, send John Doe right over. I don't know. And then about our schools, the way the curriculum that they have now is just, right, let's get back to basics. Some math, some English, some science, keep it simple. They just, I mean, there's just so much behind it. That's the thing is it's, oh yeah, I remember that snipe hunting. Oh, that was a good one. Yep. Mowing lawns, to make a little extra money, collecting cans, whatever. Of course, don't forget about having to feed the animals, raising animals. Yeah, I definitely like the woods. I do. It's one thing I liked about Idaho. Uh, I guess in the like 90s, there's when it all really just went crazy. Mid 90s, we started having 30 to 40,000 people moving in here a year, and now it's just gotten exponential. Boise itself is it's insane, and not just Boise. I mean, like the whole surrounding area, we're starting to turn into one big, huge metropolitan city. You can't tell the difference between Boise and Meridian, or Meridian and Nampa and Caldwell. It's all just kind of like starting to grow together. There's no uh, there's no real clear distinction when you're leaving from one city to the next. It's just, oh, here's city limits here. Now you're entering another city. All the all the empty, not empty, but bare farmland and all that stuff. There's just massive amount of neighborhoods been piled in here and built. I keep talking to my family about picking up and selling and getting the heck out of town, but can't convince them to do that yet. So we'll see. We will see. Right? Yeah. It is sad that the kids nowadays they just don't know the fun games that we all grew up doing. That was some good times, good wholesome fun back then. Now it's video games and computers of some sort, either your cell phone, tablet, laptop. Heck, some people don't even have desktops anymore. So, with no further ado, right? We'll see. Uh, Remember where we left off on Friday? We're return to that document because getting into the real juicy parts to that particular document. It's going to blow your mind on some of this stuff because I mean, I was like, wow, this is actually written like this back then. Yep, sure is. So this is back to the laws of the territory. Oh, wait. Yeah. The laws of the territory of Idaho, first legislative session. And this is under the Criminal Practice Act, which the Idaho Code does cite. Um, Cites this act. So I don't see why it's out of date. So this particular section here, chapter 3, is the complaint and proceedings thereon to the commitment. What's all inclusive in that? Well, we have the complaint, who are magistrate to examine complaint on oath, deposition, what to set forth, warrant of arrest, when to issue, form of, name of defendant, date and signature of warrant, How executed by peace officers, warrant to whom directed. I mean, man. Proceedings on arrest for felonies, same for misdemeanor. Bail to be certified on warrant, defendant, when to be taken before magistrate. Same other than the one who issued the warrant. Proceedings on complaint for offense, triable in another county. Duty of officer, arrest. By whom to be made, at what time to be made, how made, office, this is a really good section here. Proceedings after arrest. Wait till we get into that time to procure counsel and examination. Like the part where it says that when they take you before the magistrate, the nearest and most accessible magistrate, when they're making an arrest without a warrant, or even on a warrant, that we have actually the right to call for our assistance of counsel, and the officer is actually supposed to go and find that man and bring that man before the court as our assistance of counsel. It's amazing it doesn't talk about members of the bar. Oh, that's right, because the bar wasn't created yet. This is in 1864. American Bar Association wasn't created until 1887. Gee, what did we ever do for assistance of counsel prior to the American Bar Association being created and these alleged licenses to practice law, where there is none, because you can't license a right. Murdoch versus Pennsylvania, right? Cannot convert a right into a privilege, license it, and attach a fee to it. Actually, it does talk about the sheriff departments. There's another part that's further down. I don't know if I'll get through it tonight, but man, this thing is just packed full of good stuff. And this is just the first legislative session for the territory of Idaho. I can't even imagine what other 16 years of stuff that's in there. But this is like the golden nugget stuff, right? This is the fundamental principles of due process of law. This is the process that is due. And I've noticed that in the Idaho Code, and in comparing the Idaho Code to the actual act, they do take out words. And you'll see here, they actually leave out whole sections of how this is supposed to work. Let me tell you, some pretty interesting stuff here, folks. So, what is the complaint? The complaint is the allegation made to a magistrate that a person has been guilty of some public offense. Now, remember, we discussed what a public offense was. The magistrate is an officer having power to issue a warrant for the arrest of a person charged with a public offense. The following persons, see, there's them persons again, are magistrates. First, the justices of the Supreme Court. Second, the probate judges. Third, justices of the peace, and others upon whom are conferred by law the powers of justices of the peace. That's it. But see, all of them are magistrates. When a complaint is laid before a magistrate of the commission of a public offense triable within the county, he must examine on oath the complainant. Oh, wait, that's not plaintiff? That's right. The proper word is complainant. And notice it doesn't say anything about going through the prosecuting attorney, does it? Oh, wait, yeah, it does. Wait, is it? Right. The complainant or prosecutor. That's an or. Again, this goes back to what I talk about in reading the Wisconsin Constitution, Article 1, Section 20 there, that we all have the right to prosecute our own claims. So we don't actually need the public prosecutor to prosecute it on our behalf if we so choose to prosecute our own claims. We have that right. That power is retained by the people. Okay? So, and any witnesses he may produce. Now, wait a minute. This is when you file the complaint and take their depositions in writing and cause them to be subscribed by the parties making them. The deposition must set forth the facts stated by the prosecutor and his witnesses. Slideshow, here we go. And his witnesses tending to establish the commission of the offense and the guilt of the defendant. So if the magistrate be satisfied therefrom that the offense complained of has been committed, and that there is reasonable ground to believe that the defendant has committed it, he shall issue a warrant of arrest. A warrant of arrest is an order in writing in the name of the people of the United States and territory of Idaho. Oh, wait a minute. Why does it say in the name of the people of the United States and the territory of Idaho? Signed by a magistrate, commanding the arrest of the defendant, and may be substantially in the following form. Oh, this is one of them proper forms of a warrant. People of the United States and the territory of Idaho, to any sheriff, constable, or marshal, or policeman in this territory or in the county of. So they have to specify the county because, see, warrants, typically speaking, are only good in the county that they're issued in. A complainant, not plaintiff, complaint upon oath has been this day laid before me by AB, that the crime of designated has been committed, and accusing CD thereof, the defendant, you are therefore commanded forthwith to arrest the above named CD and bring him before me at naming the place, or in case of my absence or inability to act, before the nearest and most accessible magistrate in this county. Huh. It doesn't say take them to jail, does it? I don't see that verbiage in the warrant. This is what I talked about December 24th at the Ada County Sheriff's Office when I asked them to, check on them warrants. Yeah, I verified there's 2 warrants, and I told them they're fraudulently obtained. And I said, not only that, what does the warrant say on it? Doesn't it say to bring me before him, the man who issued the warrant? Or, but it also says, or the nearest and most accessible magistrate. I'm like, exactly. So you know exactly what they say. So why aren't you folks doing that? Why aren't you following the order of the magistrate? It's what it says. Why are you not following what the warrant says to do? You're the executive branch. You're supposed to execute this order. Now, here's some more requirements. The warrant must specify the name of the defendant. If it be unknown to the magistrate, the defendant may be designated therein by any name. It must also state the time of issuing it and the county, city, or town where it was issued, and be signed by the magistrate with his name of office. The warrant must be directed to and executed by a peace officer. Peace officers are sheriffs of counties and constables, marshals, and policemen of cities and towns, respectively. I will respectively disagree because policy man, is foreign to our form of government, repugnant to our law, because it's not police, it's policy. That would be erecting a multitude of offices, sending hither swarms of officers to harass our people and eat out our substance. That is a declared act of tyranny in the Declaration of Independence. Section 109. If a warrant be issued by a justice of the Supreme Court or probate judge, it may be directed generally to any sheriff, constable, marshal, or policeman in this territory, and may be executed by any of those officers to whom it may be delivered. See, they actually have to have the physical warrant. It is required. The common law requires this. So, if it be issued by any other magistrate, it may be directed generally to any sheriff, constable, marshal, or policeman in the county in which it is issued. It may be executed in that county. Or if the defendant be in another county, it may be executed therein upon the written direction of a magistrate of that county, endorsed upon the warrant, signed by him with his name of office, and dated at the county, city, or town where it is made, to the following effect. Man, they're laying this out like this is how it is done, right? No questions. Maybe executed in the county of, or as the case may be. So they actually have to specify on the warrant. If the offense charged in the warrant be a felony, the officer making the arrest must take the defendant before the magistrate who issued the warrant, or some other magistrate of the same county, as provided in section 115, which, okay, we'll get to that. If the offense charged in the warrant be misdemeanor and the defendant be arrested in another county, the officer must, upon being so required, one of them words, mandatory, by the defendant. Oh, we have to require it. That's right. Bring him before a magistrate of such county, who shall admit the defendant to bail. Wait, it doesn't say to take them to jail? Nope, it sure doesn't. On admitting the defendant to bail, the magistrate shall certify on the warrant that the fact of his having done so, and deliver the warrant and recognize to the officer having charge of the defendant. Recognizance. Okay. The officer shall forthwith discharge the defendant from arrest. This is an indicator that the man who makes the arrest, the officer or private person, right? We'll get to that. The officer shall forthwith discharge the defendant from arrest, and shall, without delay, deliver the warrant and recognizance to the clerk of the court at which the defendant is required to appear. So they would release the defendant, then they'd run over there to the other county and file it with the clerk of the court in that county. That's what it says there. If on the admission of the defendant to bail, as provided in the section 112, or if bail be not forthwith given, the officer shall take the defendant before the magistrate who issued the warrant, or some other magistrate of the same county, as provided in the next section. This is that section 115 now. Here it is. When by the preceding sections of this act, the defendant is required to be taken before the magistrate who issued the warrant, he may, if the magistrate be absent or unable to act, be taken before the nearest or most accessible magistrate in the same county. The officer shall at the same time deliver to the magistrate the warrant with his return, endorsed and subscribed by him. So in other words, they're supposed to take you before the magistrate who issued the warrant, even if it's in a different county, or at least a magistrate in that county. The defendant must, in all cases, be taken before the magistrate without unnecessary delay. It is not necessary to take them to jail. Like, you get a flat tire on the way, hey, things happen, right? But it doesn't say to take them to jail. It doesn't say to take them to jail to take their picture and fingerprints. If the defendant be brought before a magistrate in the same county, other than the one who issued the warrant, the affidavits on which the warrant was granted, if the defendant insists upon an examination, shall be sent to the magistrate. If they cannot be procured, the prosecutor and his witnesses shall be summoned to give their testimony anew. So remember the first part, the complaint has to be laid before the court, the magistrate. Got to swear them in under oath. They got to testify, and the witnesses. Then it's got to be subscribed and sworn to. Okay, that's the way it's supposed to be done. This is the process that's due to us, folks. This is grounds for dismissal of any case, right? Because like it says, the defendant must, in all cases, be taken before the magistrate without unnecessary delay. Okay. When a complaint is laid before the magistrate of the commission of a public offense, triable within some other county of this territory, but showing that the defendant is in the county where the complaint is laid, the same proceedings shall be had as prescribed in this act, except that the warrant shall require the defendant be taken before the nearest and most accessible magistrate of the county in which the offense is triable, and the depositions of the complainant or prosecutor and of the witnesses. See, that's and. That's because you got to have two witnesses to the same overt act. This is why we have the right to confront our accuser and the witnesses against us. It's a requirement. And they have to have first-hand knowledge. That's right. Because then you're not a witness, just hearsay. So the officer who executes the warrant shall take the defendant before the nearest and most accessible magistrate of the county in which the offense is triable. I mean, they're just hammering this home. In every section, they keep reiterating, you got to take them before the nearest and most accessible magistrate or the magistrate who issued the warrant. Period. That's the law, due process of law. That the legislature has no lawful authority, has no subject matter jurisdiction to interfere and subvert that process. This process comes from the common law, American common law. The officer who executes the warrant shall take the defendant before the nearest most accessible magistrate of the county in which the offense is triable, and shall deliver to such magistrate the depositions and the warrant with his return. See, this is a clear indication they're supposed to have this paperwork. They're supposed to have been given this paperwork to execute the warrant, to serve the warrant. With his return endorsed thereon, and such magistrate shall proceed in the same manner as upon a warrant issued by himself. If the offense charged in the warrant issued pursuant to section 118 be misdemeanor, the officer shall, upon being so required by the defendant, take him before a magistrate of the county in which the said warrant is issued, who shall admit the defendant to bail and immediately transmit the warrant, depositions, and recognizance to the clerk of the court in which the defendant is required to appear. Arrest is the taking of a person into custody, that he may be held to answer for a public offense. An arrest may be either first by a peace officer under a warrant, second by a peace officer without a warrant, third by a private person. There it is. Because, fundamentally and principally, What I cannot do in my person, I cannot do through the agency of another. We cannot delegate a power that we do not possess ourselves first, considering all political power. Now, this is politics, policy making power is inherent in the people. Policy making. That's the 10th Amendment. Policing powers, policy making powers, not creating standing armies and armed bodies of men. That would be erecting a multitude of new offices, right? Back to the Declaration of Independence. That is not Republican in character or conduct. Every person shall aid an officer in the execution of a warrant if the officer require his aid and be present and acting in its execution. He's supposed to execute the warrant. It's an order. Follow the order. If the offense charged be a felony, the arrest may be made on any day and at any time of the day or night. If it be a misdemeanor, the arrest shall not be made at night unless upon the direction of the magistrate endorsed upon the warrant, which later we will find out that these courts are supposed to be open all the time. Okay? For this reason, right here. Because how are you going to take them before the nearest and most accessible magistrate at night if there isn't somebody on duty? But what do we do on weekends? There's supposed to be a magistrate on duty in every single county. And again, I like to remind people about the movie called Night Court, or the TV show series Night Court. They're showing us on TV how it's supposed to work. You know, these people get arrested, they bring them into the courtroom, and they sit them there in the pews waiting for the judge. All right? These are things we're going to have to get back to. We need to get back our proper form of government and our public servants back to work where, when, and where they're supposed to be working and follow due process of law. Because if you can't take them before the nearest and most accessible magistrate, you sure as heck can't take them to jail. An arrest shall be made by an actual restraint of the person of the defendant or by his submission to the custody officers. Notice it doesn't say take them to jail. That is an arrest. It's as soon as you deprive a man of his liberty, that is an arrest. Period. The defendant shall not be subjected to any more restraint than is necessary for his arrest and detention. Meaning, hey, I've got a warrant for your arrest. Let's go see the judge. Okay. Let's go. Well, I'll hop in my rig, you can hop in your rig, and I'll follow you down there. I'll meet you down there, whatever. Not put handcuffs on you and throw you in the back of their car and take you to jail. Again, that's in the treatise on arrest and false imprisonment. Talks about how they cannot even put handcuffs on you if you're not, and their excuse today is, oh, well, it's for my own protection. No, that violates my right to due process of law. I'm cooperating with you. You're not allowed to use any more restraint than is necessary for his arrest and detention. You show me the warrant, which I would require. I'll read it and make sure that it's lawful, been lawfully obtained. And if we're going to go down and see the magistrate, then let's go. Don't need to put handcuffs on me. I'm willing. You got a lawful warrant here. Let's go. Let's go see the judge, see what the judge has to say. Let's follow due process of law here, because when we get to it, you'll see what the initial appearance is all about. There's a full-on hearing that has to happen here. Just in case some people are lying, it gets dismissed at an initial appearance. Don't even have to do a pleadings, right? Arraignment, and make a pleading and then make a motion for dismissal on certain grounds. No, it can be done right here at the initial appearance. But watch and learn, folks. Got to read. The officer shall inform the defendant that he acts under the authority of the warrant and shall also show the warrant if required. Now, this is where we have to require it. It's us that requires it. Unless you know that you have a warrant for your arrest, right? So if after notice of intention to arrest the defendant, he either flee or forcibly resist, the officer may use all necessary means to effect the arrest. Okay, I agree with that. But you have to show the warrant. You better have a lawfully obtained warrant, and you better follow due process of law in accordance with the letter of the warrant. The officer may break open any outer or inner door or window of a dwelling house to execute the warrant if, after notice of his authority and purpose, he be refused admittance. So that's if he flees and runs into a dwelling or a house, and he's already informed him, given him notice of his authority and purpose, then he can break open the doors. That's called hot pursuit, right? An officer may break open any outer or inner door or window of a dwelling house for the purpose of liberating a person who, having entered for the purpose of making an arrest, is detained therein, or when necessary for his own liberation. So let's say he gets in there, he goes to arrest the guy, and he can't seem to get out because they're locking him in. He can bust the windows and doors to get out. Okay. Peace officer may, without a warrant, arrest a person first for a public offense committed or attempted in his presence. In other words, it has to happen in his presence. First-hand knowledge. Second, where the person arrested has committed a felony, although not in his presence. Third, where a felony has in fact been committed and he has reasonable cause for believing the person arrested to have committed it. Fourth, on a charge made upon a reasonable cause of the commission of a felony by the party arrested. So, it goes on here and it talks about other parts of gives an example that they're not allowed to make an arrest. Let's say there's a fight that breaks out at the bar and the bar calls the cops and the cops show up, peace officer, right? And by the time the peace officer gets there, the two guys are a bloody mess, but they're sitting up at the bar having a beer. Can't make an arrest. Can't do anything unless you got to have the complainant. The officer can't be the complainant. To make an arrest is provided in the last section. The officer may break open an outer and inner doorway in a dwelling house. Now, notice this officer purpose for he be refused admittance, right? He may also, at night, without a warrant, arrest any person whom he has reasonable cause for believing to have committed a felony and is justified in making the arrest, though it afterward appear that a felony had not been committed. Yeah. But let's get into, what are felonies? Murder, rape, kidnapping. Okay, that's what we're talking about. Felonies, not bills of attainder. SMU, stuff made up. He may take before a magistrate. Oh, wait. When arresting a person without a warrant, the officer has, oh, yeah, must inform him of his authority and the cause of the arrest, except when he is in the actual commission of a public offense or when he is pursued immediately after an escape. Hot pursuit. So in the middle of, raping a woman, he really doesn't need to announce that he's making an arrest. Grab that sucker by the scruff of his neck and do what you got to do to stop what's going on, because that's the arrest, is to stop. He may take before a magistrate any person who, being engaged in a breach of the peace, is arrested by a bystander and delivered to him. When a public offense is committed in the presence of a magistrate, he may, by a verbal order, command any person to arrest the offender, and may thereupon proceed as if the offender had been brought before him on a warrant of arrest. So see, the magistrate can't actually make the arrest. Uh-oh. Like what happened to me? That'd be unlawful, wouldn't it? A private person may arrest another, first, for a public offense committed or attempted in his presence. Like I told him, I'm placing you under arrest for acting under color of law. Deprivations of rights while acting under color of law. The Idaho Code is not the law. Cite the law. He couldn't cite the law because that's the only law he can practice, is the code. This is the bar code. But see, a private person, again, you kind of have to understand the person here. Like me, Kirk's Law Corner LLC. I'm not a public entity. I don't receive any subsidy from the government. I am in the private. So me as a private person may make an arrest for a public offense committed or attempted in my presence. Second, when the person arrested has committed a felony, although not in his presence. Third, when a felony has been in fact committed and he has reasonable cause for believing the person arrested to have committed it. It's exactly the same as a peace officer. That's right, because that's where that power comes from. We have that power first. He must, before making the arrest, inform the person to be arrested of the cause thereof and require him to submit, except when he is in the actual commission of the offense or when he is arrested on pursuit immediately after its commission. He didn't submit to me when I placed him under arrest. His comment was, well, you might have me arrested sometime down the road, but it's not going to be here today. Why not? You're committing a felony. I informed you that you were committing a felony and cited the code that you were in violation of. And that would be United States Code annotated. That's actually a legitimate code because it cites the public law behind it. You don't cite public law behind your Idaho code. You try sometimes. Right. Yeah, I'm sure. Now, he must, before making the arrest, inform the person arrested. Okay, actual commission. Okay. If the person to be arrested have committed a felony and a private person after notice of his intention to make the arrest, be refused admittance, he may break open any outer or inner door or window of a dwelling house for the purpose of making the arrest. Imagine that. We can do exactly the same thing that they can do. Private person who has arrested another for the commission of a public offense must, without unnecessary delay, take him before a magistrate or deliver him to a peace officer. Would you look at that? If a person arrested escape or be rescued, the person from whose custody he escaped or was rescued may immediately pursue and retake him at any time and in any place within the territory. To retake the person escaped or rescued, the person pursuing may, after notice of his intention and refusal of admittance, break open any outer or inner door or window of a dwelling house. When the defendant is brought before the magistrate upon arrest, either with or without warrant, on a charge of having committed a public offense, the magistrate shall immediately inform him of the charge against him and of his right to the aid of counsel in every stage of the proceedings and before any further proceedings are had. Oh, but see, this is part of what they tried. Let me advise you of your rights. You have the right to be represented by a member of the bar, or actually represented by an attorney. No, I have the right to the assistance of counsel. That's what it reads as it is written, not what you say it says. So that's a lie. He shall also allow the defendant a reasonable time to send for counsel and adjourn the examination for that purpose, and shall, upon the request of the defendant, require peace officer to take a message to such counsel within the township or city as the defendant may name. The officer shall, without delay and without fee, perform that duty. So the officer is supposed to take you before the nearest supposed accessible magistrate, and when you demand your assistance of counsel and name that man, that officer has to go out there without delay and without fee and perform that duty. Imagine that. They can't even proceed any further and they have to adjourn, which means you sit there in the pew in front of the judge while the officer, without delay and without fee, goes out and finds your assistance of counsel that you have named. Notice it doesn't say, well, only those that the judge says it's okay to do. No, whoever we name. Because again, the right is the right to the assistance of counsel, not to be represented, the straw man, a corporate fiction being represented. Well, you can represent yourself. No, I can't represent myself. I am myself. How in the hell do I represent myself when I'm only just one man? Right? Just look at it. Would you just look at that? He shall also allow the defendant a reasonable time to send for counsel adjournment. Okay. The magistrate shall, immediately after the appearance of counsel, or if defendant requires the aid of counsel, after waiting a reasonable time thereof, proceed to examine the case. The examination must be completed at one session, unless the magistrate, for good cause shown, adjourn it. The adjournment cannot be for more than 2 days at each time, nor more than 6 days in all, unless by consent or motion of the defendant. If an adjournment be had for any cause, the magistrate shall commit the defendant for examination, admit him to bail, or discharge him from custody upon the deposit of money, as provided in this act as security for his appearance at the time to which the examination is adjourned. So at a minimum, I should say, pardon me, at a maximum 6 days for this initial appearance hearing. This is where it gets interesting. The committee for examination shall be by an endorsement signed by the magistrate on the warrant of arrest to the following effect. The within name, BAB, having been brought before me under this warrant, is committed for examination to the sheriff of the county of, name the county. If the sheriff be not present, the defendant may be committed to the custody of a peace officer. At the examination of the magistrate shall, in the first place, read to the defendant the depositions of the witnesses examined on the taking of the information. He shall issue subpoenas for any witnesses required by the prosecutor or the defendant, as provided in section 535. So remember, not just the prosecutor here. Notice they're kind of straying away from, we can also do this. The witnesses shall be examined in the presence of the defendant and may be cross-examined in his behalf. Or we could cross-examine, right? When the examination of the witnesses on the part of the people is closed, the magistrate shall distinctly inform the defendant that it is his right to make a statement in relation to the charge against him, stating to him the nature thereof. Is it criminal in nature or is it civil in nature? Not to be confused with a public offense, criminal, and civil practice and criminal practice. No. In what nature is this? That the statement is designed to enable him, if he see fit, to answer the charge and to explain the facts alleged against him, that if he is at liberty to waive, that he is at liberty to waive making his statement, and that his waiver cannot be used against him on the trial. This is where you exercise your right to remain silent. But if they're full of crap and they're lying, that's where you want to make those statements, right? But you get to cross-examine them. So, if the defendant waive his right to make a statement, the magistrate shall make note thereof immediately following the depositions of the witnesses against the defendant. But the fact of his waiver shall not be used against the defendant on trial. Now, I want to back up just a little bit here. So let's say like a traffic incident, and you're refusing to identify yourself and that kind of stuff, because this next section is going to clarify this. Oh, well, you're resisting and obstructing. I'm doing an investigation here. I don't give a rat's ass what you're doing. You're depriving me of my liberty, so you're making an arrest. And you better articulate the crime that I've committed that you're making this arrest on. And who is the accuser? Because the officer can't be the accuser. That's right. Pay attention. If the defendant choose to make a statement, the magistrate shall proceed to take the same in writing without oath and shall put the defendant the following questions only. Here are the questions that the judge can ask. What is your name and age? Where were you born? Where do you reside? And how long have you resided there? What is your business or profession? Give any explanation you may think proper of the circumstances appearing in the testimony against you, and state any facts which you think will tend to your exculpatory evidence, right? Now, why is that the magistrate is the one that's supposed to ask those questions? Because that's not the officer's job. His job is to make the arrest and take you to the nearest and most accessible magistrate. Uh-oh. So resisting and obstructing a lawful order to give your name is not a lawful order. That's right. The answer of the defendant to each of the questions must be distinctly read to him as it is taken down. He may thereupon correct or add to his answer, and it shall be corrected until it is made comfortable to what he declares to be the truth. So, when they write your name in all capital letters, that's not the truth. And we're going to sit here and go over it and over it and over it until you get it right. Because that would be due process of law. The statement must be reduced to writing by the magistrate or under his direction and authenticated in the following form. Again, proper form. First, it must set forth in detail that the defendant was informed of his rights as provided by Section 151, and that after being so informed, he made the statement, which is the right to remain silent. It must contain the questions put to him and his answers thereto, as provided in Sections 153 and 154. Yeah. Can't wait to go through this tomorrow. Second, it must contain the questions put to him and his answers thereto as prior to the section. Okay. Third, it may be signed by the defendant or he may refuse to sign it. But if he refuses to sign it, his reason, therefore, must be stated as he gives it. It must be signed and certified by the magistrate. So let's say that they want to continue to write your name in all caps, and you say, look, man, I keep telling you, that's not my name. That's not proper English. That's a foreign language. I'm not declaring that to be my name. I'm declaring it to be Kirk, capital K-I-R-K, of the Pendergrass family, and my date of birth and where I live and what my business is. I'm not going to sign that. I'm going to refuse it for cause for fraud. That's how I would sign it. Refused for cause, and the cause is for fraud. So after the weight of the defendant make a statement after he's made his witnesses, if he produce any, shall be sworn and examined. So this is still at that initial appearance when the peace officer or the private person making the arrest is to bring you before the nearest and most accessible magistrate, lay that complaint before the magistrate. This whole frickin' process happens right here on the frickin' spot from start to finish, unless there's grounds to stop it. But in no less than 6 days, and he's got to release you on your own recognizance or bond. But if there's sufficient those answers that you're answering, hey, I'm a business owner, I live here, I've lived here for 30 some years, or in my case like 50 some years, okay, whatever. Yeah, I think you've got enough contacts with our society, you're not going anywhere. I'll just release you on your own recognizance, and we'll see you back here at this date and this time in a couple of days to finish the initial appearance. So the witnesses produced on the part of either of the people or of the defendant shall not be present at the examination of the defendant. And while a witness is under examination, the magistrate may exclude all witnesses who have not been examined. Right. That's so that you don't get some conspiring going on and go, oh, yeah, that's right. So-and-so said that, so I get to say that. No. Got to keep the witnesses separate. So I know people out there talk about how they've gone to court and, well, I couldn't sit in there. Yeah, that's because you're a witness. And only after you give your testimony can you sit in the courtroom and watch the rest of the proceedings. If it's specific to that particular hearing is taking of witnesses, you can't be in the courtroom while other witnesses are testifying unless you've already testified. So that's what that's saying there, which is legitimate in my mind, so you don't get that cross contamination. He also calls the witnesses to be kept separate and to be prevented from conversing with each other until they are all examined. Yeah, that's right. The magistrate shall also, upon the request of the defendant, exclude from the examination every person except his clerk, the prosecutor and his counsel, the attorney general, the district attorney of the county, the defendant and his counsel, and the officer having the defendant in custody. Now, this appears to me, again, we're talking about them persons as public servants. Because look at that up just in 157 there, talks about the witnesses produced on part either of the people or of the defendant. Remember, the defendant's supposed to be that person for a public offense. But you still have to have one, at least one of the people to be the victim here. I mean, you can't necessarily make a breach of the peace if you don't have a complainant. The officer can't be the complainant. Now, I've actually run into this before. Well, did you want to file charges against him? No, I'll let him slide this time. They can't arrest the guy because they don't have anybody who's to be the complainant here. One of the people to be the complainant for a public offense. Hey, Doug, how's it going, brother? Out here on YouTube. See you. I see you. Now, after hearing the proofs in the statement of the defendant, if he have made one, if it appear either that a public offense has not been committed, or there is no sufficient cause to believe the defendant guilty thereof, that the magistrate shall order the defendant to be discharged by an endorsement on the depositions and statements signed by him to the following effect: there being no sufficient cause to believe the within named AB guilty of the offense within mentioned, I order him to be discharged. Yeah. When does that ever happen? Because they never do this frickin' initial appearance hearing. If, however, it appears from the examination that a public has been committed and that there is sufficient cause to believe the defendant guilty thereof, the magistrate shall, in like manner, endorse on the depositions and statement and order signed by him to the following effect: it appearing to me by the within depositions and statement, if any, that the offense therein mentioned, or any other offense according to the facts stating generally the nature thereof, not why isn't it? Oh, well, he's in violation of Idaho Code section blah 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 blah. That's not how it's supposed to work. These crimes are supposed to be relative: breach of the peace, assault and battery. Now pay attention here. Remember, from up above, all public offenses are at least a misdemeanor, and they all have to go through a grand jury indictment. All of them, except for the ones that do not exceed 6 months jail time. If it exceeds 6 months jail time, it is required. That's that in all criminal or all capital offenses and infamous crimes shall be tried by what? Indictment. Uh-oh. Yeah, it would be that Fifth Amendment requirement, If necessary and an offense according to the facts stating generally the nature thereof has been committed, and there is sufficient cause to believe within named AB guilty thereof, I order that it be held to answer the same. If the offense be not bailable, like murder, rape, kidnapping, the following words or words to the same effect shall be added to the endorsement, and that he be committed to the sheriff of the county of. See, capital offenses are not bailable. They're not supposed to be. Right on. So, if the offense be bailable, a bail be taken by the magistrate. So right here, while you're standing in front of the magistrate, you can give bail. Not go to jail, call a bondsman, and wait. The following words or words to the same effect shall be added to the endorsement. And I have admitted him to bail to answer by the recognizance hereto annexed. If the offense be bailable and the defendant be admitted to bail, but bail have not been taken, the following words or words to the same effect shall be added to the endorsement mentioned in section 160, and that he be admitted to bail in the sum of dollars and be committed to the sheriff of the county of until he gives such bail. Now, there you go. Look at that. Would you just look at that? So if the magistrate order the defendant to be committed as provided in sections 161 and 163, he shall make out a commitment signed by him with his name of office and deliver it with the defendant to the officer to whom he is committed, or if that officer be not present, to a peace officer who shall deliver the defendant into the proper custody together with the commitment. The commitment must be to the following effect: county of, as the case may be, the people of the United States and the territory of Idaho, to the sheriff of the county of, an order having been this day made by me that AB be held to answer upon a charge of, stating briefly the nature of the offense, and as near as may be the time when and the place where the same was committed, you are commanded to receive him into your custody and to detain him until he be legally discharged. There's that word, detain, synonymous, ain't it? On holding the defendant to answer, the magistrate shall take from each of the material witnesses examined before him on the part of the people a written recognizance to the effect that he will appear and testify at the court to which the depositions and statements are to be sent, or that he will forfeit the sum of $500. Now, here's another part that's in here, is it sets what the bail is. None of this going, oh, well, it could be up to 50,000. It could be this, it could be that. No. That's so there's not any extortion going on. And it also allows the people to be able to bail out. They don't set your bail so high that you can't bail out. Whenever the magistrate shall be satisfied by proof on oath that there is reason to believe that any such witness will not fulfill his recognizance to appear and testify, unless security be required, he may order the witness to enter into a written recognizance with such sureties and in such sum as he may deem meet for his appearance and specified in the last section. Wait a minute. That's requiring the witnesses a bond. Let's back up to 166. On holding the defendant to answer, the magistrate shall take from each of the material witnesses examined before him on the part of the people a written recognizance to the effect that he will appear and testify at the court to which the depositions and statements are to be sent, or that he will forfeit the sum of $500. That's because the bond is supposed to be $500. And if for the defendant, as well as for the witness. And that's each of them. They have to sign saying that they would forfeit $500 after they've come in and were a material witness and they were examined. And a written recognizance, they got to sign that saying, yes, yes, I will appear and testify when called upon. Or they forfeit the sum of $500. When other magistrates shall be satisfied by proof on oath that there is reason to believe that any such witness will not fulfill his recognizance to appear and testify, unless security be required, he may order the witness to enter into a written recognizance with such sureties and in such sum as he may deem meet for his appearance as specified in the last section. So it can actually up to $500, right? Infants and married women who are material witnesses against the defendant may in like manner be required to procure sureties for their appearance as provided in the last section. Wait, why are witnesses supposed to do that? That's so that we make sure that you're telling the whole truth, telling the truth, the whole truth, nothing but the truth, so help you God. And then we don't waste the court's time when you decide not to show up. They still get paid one way or another. So if a witness required to enter into a recognizance to appear and testify, either with or without surety, refuse compliance with the order for that purpose, the magistrate shall commit him to prison until he comply or be legally discharged. So you can actually have the witnesses against you arrested if they don't want to do that. But most of the time they do, right? So when, however, shall satisfactorily appear by the examination on oath of the witness or any other person that the witness is unable to procure sureties, he may be forthwith conditionally examined on behalf of the people. Such examination shall be by question and answer, and shall be conducted in the same manner as the examination before a committing magistrate is required by this act to be conducted, and the witness shall thereupon be discharged. Would that be that grand jury, the commission? The last section shall not apply to the prosecutor or to an accomplice in the commission of the offense charged. When a magistrate has discharged a defendant or has held him to answer as provided in sections 160 and 161, he shall return without delay to the clerk of the court at which the defendant is required to appear, the warrant, if any, the depositions, the statement of the defendant, if he has made one, and all recognizance of bail or for the appearance of witnesses taken by him. All right. Now, imagine that. Proceedings after commitment and before indictment. Uh-oh. That's a requirement, isn't it? It sure is right here. But that'll have to wait till Friday. We're out of time tonight. So again, reading means reading. Knowledge is power. The code, Idaho code specifically here, does not have all of this great information in there, right? Because they were allegedly granted the power to write whatever they want to write in there. Just saying. So I hope you all enjoyed that. And that was quite educational for a Monday night law. Good times. Tease again. Well, you know, hey. We covered some really good stuff there. So anyway, more to come, right? This is really what Monday Night Law really supposed to be about, is showing you the law. But hey, it's what I've been doing for years now. So Well, here's the thing. I truly believe and think that a lot of people, majority of the population, has not read this stuff. They do not know this stuff on purpose to deceive even our sheriff and the sheriff deputies and the police officers, right? And the marshals and everybody, because they want them to do their evil deeds, and they write their code in such a way that, oh, but see, even according to the code and the rules of procedure, it specifically says that you got to take them before the nearest and most accessible magistrate, that you cannot require them to post bond or incarcerate them until after an initial appearance. Why are they not following that? I brought this up back in 2014, and the judge was like, well, that's just the way we've done it for the last 95 years. Well, my response was, well, so you're openly admitting that you've been screwing the people over for the last 95 years? Although he's not 95 years old, but he's been made aware of it. So my ultimate question is this: how does he know it's been going on for the last 95 years? And what happened 95 years ago that allowed them to subvert due process of law, or to even subvert the Idaho code, even though that's not law? But nonetheless, lawful notification letters, folks. Put them on notice of the law and afford them the opportunity to do the right thing. That's to answer the question out there from Shirley over here on Facebook. How can we educate our sheriff's department and make them listen? Put it in writing. Afford them the opportunity to respond. Okay? That's the first fundamental principle of due process of law. Notice an opportunity to respond. So, with that, again, I'm putting out the request and to send any donations over there to help me get into this new office space at the current office, which again, I'm trying to get in there July 1st, which I just talked to the owner again today. 6477 West Fairview Avenue, Suite C, Boise, Idaho 83704. I'm right at the halfway mark. I did get one that came in over the weekend, which I got it this morning. Small donation there, so thank you for that one. But I'm really looking forward to trying to get in there. If I can't get enough money to get in there, I don't know. I've got enough money basically for the initial part, but they want first and last month, and it's $1,600 a month. So of course, then there's going to be NNNs, and I got to get power in my name and all that good stuff. So roughly, I'm looking around $2,000 a month just for this building. That doesn't include all the other bills such as internet, paper, ink, and all that other fancy stuff. But we did get into a better printer, so ink's not really a big problem for that printer because it prints 10,000 pages on black and 15,000 on the colors, and it's 4 different cartridges, and it's a laser jet, and those cartridges are $100 for all 4. So I just picked up a set of those, so I'm good on ink for quite some time. So want to thank everybody out there, especially with the help getting that particular printer and everything else that's been going on. I want to thank all of the supporters out here. Thank you for your donations and your love and your prayers, because that's definitely needed. Lots of stress added here given the 3 cases I've got pending right now, but it's go time on my own personal cases. Watch what happens. We'll see what happens. I got court tomorrow on the 1 at 2:30 in the afternoon. We'll see what happens. And that's the one in the other county for that fraudulent document they tried giving me from 2-3 years ago that I called out as a forgery, which I just discovered that today. The date's wrong and the signature doesn't match. Like I called it out at the video arraignment, where you skipped over the initial appearance and failed to bring me before the nearest and most accessible magistrate. Right. You forgot to do that. The documents that I have that I received, which were the temporary, extending the temporary protection order out of family law, not a criminal protection order like they wrote on, oh, this is a criminal protection order. No, it's not. And that's all you cut and paste and fabricated the whole damn thing. I looked at the signatures on the legitimate ones that I had received. All of the signatures are the same on the ones that I have, but it doesn't match the signature to the one that they gave me when I was in jail. And that they wanted me to sign it saying that I received it. 3 years later, you want me to sign your forged, fraudulent document? Not a chance, dude. And I'll remind you all, I defeated that protection order. Judge dismissed all of her claims. Idaho's Department of Health and Welfare did the unsubstantiated claim letter. So I don't know how the judge granted a protection order for my son because of what the parenting coordinator said, which then the parenting coordinator subsequently resigned because I put them all on notice of intent to sue them for conspiring to deprive me of my rights, which is what the violation of the protection order was to begin with. Is, oh, well, you made contact through email. Yeah, I put her on notice of intent to sue her. I don't care what protection order you got. You don't get protection from being sued for fraud. What you're doing is a lie. And then the fact is, when we did go to court and you had to get up on the stand and I got to cross-examine you, and I asked you specifically, any evidence here to support your claims here today? And went one by one right off of the protection order, all of the grounds that are on there, and you answered no to all of them. And then I asked if you went to law school, which she did, but she didn't complete it. And I said, well, did you pass? Well, no, I didn't complete it. And then it was, well, you do know that ignorance of the law is no excuse, right? Her response was, well, I think I've heard that somewhere before, but I'm not sure if it's true. And the judge was like, oh, okay, I'm dismissing all of her claims. Like I said in the very beginning of all this, that this petition is riddled with perjury, false statements signed under penalty of perjury. Perjury is a felony, which carries 1 to 14 years prison time in Idaho. That's what I told the judge at the beginning of all that. Then when we went through the trial and he dismissed all of her claims, why didn't he arrest her and her attorney? Because the Idaho Rules of Professional Code of Conduct specifically state they're not allowed to represent fraud. That's what I said in the beginning as well, and I cited it. So, no, I won't be able to go live tomorrow. It's this is good in person, right? Canyon County. In fact, Canyon County over there is one of the 4 counties in that resolution that abolished all of that crap, right? The mask and the whole 9 yards. And in fact, Canyon County courts are actually dismissing all of anybody who has to deal with a mask charge, not wearing a mask. Canyon County courts are dismissing all of them. They're not hearing any of them. Why? Because imagine what the resolution says. Declaration of Independence, Article 1, Section 1, Article 1, Section 10, and ethics in government, that it's none of government's business. Right. That's actual law. They didn't cite any code. And because of that, they know that what they did was unlawful, and they're all screwed. So we will see what we can do. But I'm going to probably do a request for an audio recording of the hearing tomorrow. So, nah, I'm down here by the Capitol right now. I'm in prime location, the Idaho Capitol, the Idaho Supreme Court, and the federal building. They're all right down there in the same exact area. So, besides, it gets a little too cold and snowy up there in the panhandle of Idaho. But hey, I might be looking for a new place to live, to move to after all this, after I get done suing the crap out of them. So, I may have to retire after all that. Can't give this up. Got to get my people educated. All right. So don't forget your the likes and the follows and the shares over there and over here on YouTube. Thumbs up on YouTube. Don't forget to check your subscription and your notification bell there to make sure YouTube hasn't removed you from there, which other people, it's actually happened to me on other people that I followed. Like, I know that I was subscribed to this channel. I know that I clicked on the bell and said I want all notifications, and it's been removed. So there's some hokey pokey stuff going on out there. But so check that if you're out there on YouTube. All right. And look forward to my patrons over there on Patreon for Wednesday night workshop. All right. Much love, everybody. Have a wonderful night. And see you all, the rest of you all over here on Friday Night Fun Night. All right. Good night, everybody. Much love.